All right. Good afternoon, everybody. I'm Yvonne Martinez, Pro Bono Coordinator at the Center for Arkansas Legal Services. Thank you all for being here today and being, here on the stream. Today we have one of our wonderful volunteers, Kevin Odum. He takes a lot of our SSI, SSDI cases through our Vocals program, which is our pro bono program here in Central Arkansas. If anybody is ever interested in any pro bono volunteers in any capacity, whatever you can do for us, we greatly appreciate. And of course, I'm sure my colleague here, Christy Park, who is in charge of all just checking the chat and passing on the questions, can pass you my information if you're interested. But without further ado, I would like to introduce Mr. Kevin Odum, who is presenting today for our CLE.
Thank you. Good afternoon. I'm going to go without a mask for right now and try not to walk around too much. I was telling a judge that's in the audience that when the pandemic hit, Social Security, because of the virus, decided they weren't going to have in-person hearings for a while. They were going to do everything by phone. And since then, it kept pushing things out until the end of the year. They just said, okay, we're going to start looking into doing hearings by video. And so now we're doing hearings at this point by Microsoft Teams instead of doing them but you can still do it by telephone if necessary. So it gives you that option. So mask or no mask, I think they have the office open maybe once a week right now for Social Security, which makes it difficult on people trying to get in and file applications and stuff like that. Want to thank Christy and Yvonne for allowing me to speak. And if there are any questions as I'm going along, please feel free to stop me and ask, because it's easier to hit them then than to wait at the end. By show of hands, I've talked to a couple of y'all, but by show of hands, how many of y'all have handled a Social Security disability case? Okay, very good. Well, as the old saying goes, some of y'all, this is going to be like water runs downhill or telling Noah about the flood. But maybe you'll pick up a few nuggets along the way. And then for some of y'all, I hope it's very educational. I wanted to share with you to start out. I got a text message from a client on the Friday before Father's Day, and I thought it was poignant. It was unsolicited. I didn't ask for it. But it said, "Dear Mr. Odum, thank you so much for helping me get approved in my quest for disability. It was a long journey down this road, but with your help, I achieved a milestone. Thank you once again, and if anyone needs a good and exceptional lawyer, I will fully recommend you to them." Now, there are several words in there that I find actually fits Social Security disability. One of them was quest. This is a quest, and it is a long journey, which I'm going to show you here in a few minutes. And then for those, it is a milestone. This is a game changer for those that are in the position of where they have a shut-off notice, where they have an eviction notice, where they can't afford medications, where they can't afford food, and they're trying to figure out how to survive. Milestone is putting it mildly. I represented another gentleman down in Hot Springs, and about 2 weeks to a month before the hearing, he called and to go over what we were going to do before the hearing. And he said, "Kevin, I just want you to know that this case is important." And I said, I told him, I said, "James, they're all important to me. I don't discriminate." I said, I know one's not more important because of money. They're all the same to me. And he said, "Well, let me explain something to you." He said, "My wife and I have $10 extra money at the end of the month, or that we can carry for the month." And he said, "We go to Hot Springs, we go to Oaklawn. That's back when it cost $2 to get in." And he said, we'll spend a couple of dollars to go in, and we'll watch the horses run all day. And he said, then we'll go to McDonald's for dinner. And that's our quality of life for one day. And that's all we got. And so when we had the hearing, showed up and it was down in Hot Springs. It was in a makeshift office that they were using at the time before they have it where it is now. And James had his wife, he had his brother, he had his sister, he had his son, he had his daughter, he had his grandkids. I told him I only needed one witness, and we had a family reunion. And fortunately, we had a judge during the hearing that said, I'm going to approve the case. And about a couple of weeks later, he sent me a nice thank you note. And that's what I'm talking about when I say that these cases are the cases I love to do, because it is making a difference. I've handled personal injury cases, gotten settlements in the 7 figures. But these are the ones that help people day to day. And that's why I like doing them. The law requires that you be off work a year, or reasonably anticipated to be off work a year. So when you're applying, that's what you're doing. I represented a lady one time who was working at the time, though. She was a lady I met when I first got out of law school. And she said, I met her in May and she was limping until August. The company was going to carry her through August and then she was going to retire medically. And so obviously she was being turned down by Social Security because she's still working. And I took the case in August, and then by the following, it takes a while, as you'll see here in a few minutes. By the time we went to a hearing, she had been off work a year. And so we were able to go to the hearing and win the case. So, but that's what a judge is going to be looking at. It's have you been off work a year, or is it reasonably anticipated that you're going to be off work for a year? Now, I think in the materials, besides the fee agreement, the 1696, the 827, and the 1695, there should be, I believe, a link that you can go to apply for disability. I will caution you that when people go to apply, of course, you have to have a computer. It used to be they would just hand you a Title II application or a Title 16 application. You fill it out and you turn it in. Now they require Arkansans to go on the computer and try to figure out which application you're doing, which I think is not good, but it is what it is. I know that those that don't have a computer have the ability to do a phone interview, and I think that's another way that you can apply where you may not have the computer access. Administrative law judges, obviously you're going to be working your way toward a hearing. There are several judges in Little Rock. You can look them up. It used to be on www.disabilityjudges.com, where I would send my client and say, go look up the percentage of approval that judge gives you, and you'll understand what you're up against. The judges can range from 25% approval in the 30s, in the 40s, in the 60s. Not many. I think the one that was doing that retired at the end of last year. But you want to know who the judges are. Ironically, for me, I've got 2 judges I went to law school with that are judges. I've got one that taught me in law school. I got one that I clerked for when getting out of law school. So I've got a few that I know over there. In fact, there's another one who did recently retire. When I did my first workers' comp case that was in person, he was my judge. When I did my first Social Security case in person, he was my judge. So I had him twice in doing cases that we were in different settings. You want to know what they like. There's a judge over there that I remember one time before a hearing, he said, you know, Kevin, in real estate, it's location, location, location. I said, yes, sir. He said, well, in Social Security, for me, it's medical, medical, medical. I want to see what you have for medical records to document that the person is disabled. There's a judge over there that will grade the paper based on whether or not you can be a receptionist. They're going to see, can you, because it doesn't take a lot of education. It doesn't take a lot of heavy lifting. If you need to stand, you can stand. If you need to sit, you can sit. And so he's looking to see, can you be a receptionist? And if you can, then he's gonna not approve your case. There's a judge over there that'll sit there and ask about 6 questions. He's going to ask, are you able to take care of your hygiene? Are you able to take care of cooking, cleaning? Are you able to drive a car? Are you able to go to the grocery store? My all-time favorite that he asks is, are you able to go to church on Sunday? Any combination of yes to those questions, and he's going to disapprove the case. There's another judge over there that'll sit there and he'll specifically ask you to send in the pharmacy records, and he will count the pills. He did that in a case of mine, still won the case, but he was sitting there and there was a gap from like August to October, where September, there was no pain medication, and the amount of pills ran out at the end of August. And so he was sitting there trying to figure out, okay, what happened in September? If you had pain, how come we're not taking medications in September? And so that's another judge. So you want to know who the judge is and what they're looking at. And then you can go on, while www.disabilityjudges.com doesn't work, there's a www.ssa.gov. That's the Social Security Administration's website. You can go on it, and I looked under hearings and appeals and public data, and I was able to find the local judges here in Little Rock, as well as the judges in Fort Smith. And you can see it was updated as of May 28th of this year. And you can see how many cases they hear and how many they approve. And one judge I looked up was at 35%. Now, there was a judge who approved 80% of the time. And I always found it interesting that I only had that judge once. And you know, you always hear people when they say, okay, I've got a workers' comp case. How come Joe Blow down the road is lifting refrigerators and they're on workers' comp and I'm having to fight to get it? Or how come so-and-so down the road is on disability and I've been denied twice and I have to go in front of a judge? And I said, well, could be that person had the 80% judge, and it didn't, instead of the 25% judge that you may be having. And so the one hearing I had, though, it was for a paralegal who could not work anymore. And we went in, did the usual stuff, went over the record. He said, make your opening statement. I said, she's disabled. And then he said, you may inquire. I went 10 minutes and he said, Mr. Odum, do you know any reason why Social Security has not approved this case? And I'm like, I've never heard a judge ask me that ever. And I said, no, sir. I said, neither have I. We're done. And so then you got the judges there was a judge that was there. They used to give seminars, and he explained when they send them to training, they tell them, act like you're writing the check out of your own account. Are you going to approve that case or not? And that makes a bigger difference. And there are judges over there, you kind of have an understanding. That's what they're thinking. So know your judge. Now I've set this up. Thank you. This is what I do for anybody that comes into my office. Y'all are going to be the new clients today. I do this for new clients. I do this if it's a car wreck case, if it's a workers' comp case. What I do is I have a board that I can go over the roadmap and what to expect. And it explains, it answers questions before they even ask. And it also lets you reference later when they, instead of, you might get the call about, well, I don't know, what's next in my case. And I'll go, well, do you remember when you came in and we went over it? And just, it just gives them a framework. I've had clients take pictures of this. I think they're going to save it and give it out. So it's available to y'all. But I want to go over this. And I did this when I was a younger attorney. I had an older attorney that used to have a board in his office, and he would say he was a teacher before he became a lawyer. And he used it all the time, even though he was a prestigious plaintiff's attorney. But he liked it because it makes sense and helps people understand. If you get on the board, it's like a teacher. Everybody likes a teacher. All right. So in a Social Security case, you're first going to apply. And then obviously you're going to get turned down, and you're going to have 65 days to do what is called a request for reconsideration. And then you're going to get turned down, because nothing usually happens within the turn down and the request for reconsideration, except I won one case because I had additional medical that I was able to submit, and the additional medical carried the day. Other than that, Social Security is not going to say, yeah, we made a mistake just 65 days ago by turning you down. Now we're going to say you're disabled. So then you're going to get turned down and you're going to have 65 days. Now it's 60 and the 5 is for mail. That's why there's 5 extra days. They give you 5 days for having to get it by mail. You're going to ask for a hearing and then you're going to go before an administrative law judge. Now, I hope I can do this because I didn't do it earlier. When I first started doing these cases, from application to getting this ruling. Now, the ruling usually comes 60 days after the hearing. From application to getting this ruling used to take a year and 3 months. Used to. Now, it takes 15 months just from the date that you asked for the hearing to go before the judge. These are not overnight. This is not a quick process by any stretch. That's why when the lady said quest and long journey, she was right. It is a quest and a long journey. The last time you hear different things about how far behind are they. Okay, I've heard 8,000 cases behind. I've heard 7,000 cases behind. I've heard 5,000 cases behind. They're behind. I mean, that's a given. I've had hearings with judges in Chicago, judges with hearings in Philadelphia and New Orleans. In fact, I got a hearing tomorrow and the judge is going to be out of New Orleans. Now, I'm okay with New Orleans. It's a little closer. I'm not as okay with having a judge grading somebody's paper that's out of Chicago or Philadelphia. Do they really know Arkansas? I mean, it kind of irritates me because there are times that judges will sit there and ask questions and understand, hey, there are 2 Baptist hospitals in Little Rock. One's on Spring Hill and one's is off of 630. Well, they know that. And they might ask questions about that or know something about that. Whereas somebody from Philadelphia doesn't know we have 4 Dillards at Park Plaza or Chicago. And then plus they're looking at the sphere through the eyes of having that many people in the Chicago area or in the Philadelphia area. Whereas we don't have that many in Arkansas or and especially around Little Rock, et cetera. So you go before the judge and you're going to get a ruling. At the hearing, there's going to be a vocational rehabilitation expert that's going to listen to the age of your client, the education of your client, the work experience of your client, the last day worked, and the medical conditions that keep them from working. And then the hypotheticals are going to come from the judge. And as I heard one judge tell me the other day, it's an inverted process. And what he meant by that is at first, they're going to assume that your client has no problems. And of course, there's jobs. And then they slowly start through the hypotheticals, weeding out the jobs to where the last 2 hypotheticals are usually assume back when I first started doing these cases many years ago, assume that your client's going to miss 3 to 5 days a month. Well, tell me which employer in their right mind is going to want their client to miss that many days and be employable. Are there any jobs, Mr. Vocational Person? No, of course not. Well, when unemployment got low, and still is, obviously, they then moved this to like 1 to 2 days a month. Assume that the person's going to miss 1 to 2 days a month. Are there any jobs? No. Again, you go with the probation period of the first 90 days and you tell them, okay, you're going to miss 3 to 6 days in those first 90 days. No, thank you. So then that's one hypothetical that they'll ask. The other one is assume that the person's going to be off task 15% of the day. And that's, of course, with people that may have a bad back, neck, may have to lay down during the day. And they say, okay, now if you're going to be off task, are there any jobs, Mr. Vocational Person? No. So what do we have? We have a tummy test. We're back to, we have jobs and we don't have jobs. That the person, if they're going to be off work 3 to 5 days or 1 to 2 days and going to be off task, 25% of the time, 15% of the time, 20% of the time, whichever way they want to ask it, there are no jobs. So it ends up going back to those percentages I was telling you about. Do you have the judge that's 25%? Or do you have the judge that's 80%? Or do you have the judge that's 45%? And then do you have enough medical? The jobs that you're going to hear, the yardstick is, can you do any job in the United States? And when I say any, I mean any. I represented Darren McFadden's half brother one time at a hearing, and the jobs that I got to hear was clothes folder and basket filler. And to this day, I don't know what a basket filler is. I could kind of surmise what a clothes folder is. You know, I'm maybe working at a laundromat or a dry cleaner. I didn't know what a basket filler was. When I first started doing these cases, I would say they're looking to see, just like the judge, can you be a receptionist? You can go down to receptionist, parking deck attendant, night watchman, cashier at a convenience store, Walmart greeter. They're looking to see any job, and I mean any job. Because people sometimes think, well, I can't do the job I was doing if I was a CNA. That's not what we're going after. Yeah, you can prove you're not a CNA anymore. They're looking to see, can you do anything? Then the other thing is if you can do any job, the yardstick is, can you do what is called substantial gainful employment? Substantial, not 2 hours a day, not 4 hours a day, not 8 hours a day, not back-to-back 8 hours a day. Substantial. Can you do 8 hours a day, 5 days a week, week in, week out for an extended period of time? I had a lady one time that I was representing that she wanted to go back to work during the process. And her husband was in the construction business. And she said, I'm going to go back and paint walls. I'm not art, I'm going to just go slap paint on walls. And she said, is that okay? And I said, sure, go try. And she made it about 2 weeks, and that was it. So the reason I said yes was because it showed a couple of things. One, she still wanted to work. And under the law in Social Security, it's called an unsuccessful work attempt, meaning you tried and it failed. And so, but to the judge who's looking at it, at least she tried. She's not in the, we're just sitting at home, eating pizza, drinking beer, waiting for the gravy train to come home on this case. She tried. And so when you'll get that question pretty much a lot if you handle a volume of these, and that is, can I try to go back to work? And I always answer it as, well, when I was a younger lawyer, I would have answered that question differently than what I am now. I said, as a young lawyer, I'd say you're going to affect the case. Obviously you applied for disability, right? And if you're going to go back to work, well, then what are we doing? As an older lawyer, you understand that people have to survive. You understand that they have to have a roof over their head. They have to have food. They have to have medication. They might be the only sole provider. Interestingly enough, I represented a gentleman that I'd represented his dad and won his case. So the son came in to see me, and I signed him up, and we were right at the turn down phase. And I signed it up. I'm going to do the request for reconsideration. He called me the next day and he said, Kevin, I can't do it. My wife doesn't work. We got 2 kids. I got to go back to work. I'm the sole breadwinner. I said, okay. His name was Jeremy. I said, Jeremy, let me do this. Let me keep the case going. And in that way, what happens in Social Security is when they get close to the time of sending us the hearing notice, it'll be about 3 months out. Back then, they'd actually call an attorney and say, hey, we're trying to schedule Jeremy's hearing. Now they just send you a notice and say, here it is. But it'll still be a ways out. I said, when I get that hearing notice, I'll call you, and then we can see where you are. And sure enough, request for reconsideration got turned down, asked for the hearing. We get time for the judge. Got the hearing notice, called Jeremy. I said, now I know you said you were going to go back to work. He said, man, I couldn't. I never did. I tried, but I didn't make it, and went to a hearing and won on a case that if I'd have taken his advice and went with him, we'd have shut the case down at the turn down and we're done. And yet we kept going. And so he thanked me later. So it's substantial gainful employment. is what you're looking at. Because you're going to have good days and bad days, as everybody, you know, when they talk about, yeah, my back may be okay for a couple of days, and then I may not be able to do anything on the third day. So the way I prove a case is this word right here, dependable. Dependable. And that goes back to the obvious, assume 3 to 5 days off, or assume 1 to 2 days off. I will admit that at one time I had 3 secretaries in a row I had to fire. And I had to fire them because out of a 5-day work week, I could guarantee you they'd be there 3. And I didn't know which 3. And the last one I let go, it was on a Thursday. I had 5 appointments and she wasn't there. The next day was payday Friday, casual Friday. Guess who showed up? And that was her last check. So dependable. That's going to be what you're trying to get down to in terms of showing a judge that it's not a character assassination. I always tell my people, this isn't a character assassination. We're not asking, are you a good or bad person? Are you a good or bad spouse? Are you a good or bad parent? It's, can you work? Because people's self-esteem is tied into working, as everybody knows. And I've seen grown men cry in this kind of situation when they know they can't be the breadwinner for their family. And they're not, it's not because they don't want to be. So as I tell my people, when you're doing this, the first thing, don't get to the next step. We got to prove that you're disabled first. If we don't prove that you're disabled, we're not even talking about anything else. It doesn't matter what the benefits could be, might be. It's, can we prove you're disabled? All right, now let's get to Title II and Title 16. These are the 2 applications you normally file, and they are different in terms of what they require and the benefits you can get. Title II is what I call the true Social Security disability. It's kind of what the program was built for. You have worked and you've paid into the system. And what the law requires is that you've paid in 5 full years out of the past 10. 5 full years out of the past 10. The benefits can start, you'll hear date of onset, can start at your last day worked. And the benefits can be approximately $1,500 a month. It can go up to $2,400 a month. It can be less based on what you paid into the system. It's just, and Social Security does these numbers. They know the numbers because they got your tax returns. I tell my people, my goal is to win the case. After that, Social Security can tell us what the numbers are, because they will. They'll go through them and go over them. They used to send us, I don't know if some of y'all remember, they used to send us a green card in the mail at the end of the year, every year. And it would tell us, if you become disabled, you can get about 16. They quit doing that. I think they probably felt like they were feeding the system. Oh, well, if we tell them they can get this much money by being disabled, they're going to go apply. Well, stop doing that. Don't tell them that. Now they want you to go online and open up an account and then figure out, okay, what might things be? All right, Title 16 is if you don't have 5 out of 10 years, you apply for Title 16. It's based on income, and I'm going to get to that in just a minute. It'll go from the date of application, and the government usually right now, I think it's set for around $800 a month. So obviously there's a difference. You know, when you can go up to $2,400 and you go to around $800. I represented this lady one time, and I know there's, if you've handled cases, you'll have your 1 or 2 stories. It was a lady that we were close on the 5 out of 10 years. We had 4 years, 9 months. I knew that. However, I was kind of hoping maybe by luck, there might be an extra 3 months found along the way that could help us get to Title II. However, I also knew that if we didn't have Title II, we still had Title 16 to fall back on. And so we were still going to, whether or not we would get $1,500 a month or $800 a month, we were going to get something. Back then, I had an interview sheet because I used a vocational person to combat this vocational person. I would use one, and then I got away from doing that. But I had an interview sheet, be about 7 pages, kind of go over anything and everything my vocational person needed to hear. So this lady that I represented, I will remember forever, because she was one that would call probably every 2 weeks during this 15 months wait, that would ask the same question: where are we in the case? What's the status of the case? And I could only say the same thing every time: waiting on a hearing, waiting on a hearing, waiting on a hearing. Well, we went to the hearing, and the judge, we were waiting in the waiting room, and the judge had the trial assistant, the court reporter, come get me and said, the judge wanted to see you. And I walked in, and he said, hey, Kevin, I'm going to approve the case on the record. I just need her to testify about a few things: name, address, just give me a little bit of something on the medical, and we're done. Cool. Went back in there, and I said, Patricia, you won. And she let out a scream like the Razorbacks just scored a touchdown. And takes usually 60 days later, I get a phone call. And she said, my benefits are $16.73 a month. And I was like, what? And she said, my benefits are $16.73 a month. I said, I've never heard of that. She said, well, that's what they're telling me. And then she uttered the words that helped educate me. She said, I'm using this case to get away from my husband. And I went, oh, no, you didn't just say that. And I had those back then. I had the headset that you could walk and talk on the telephone, and it was connected to your phone. And I went straight to I already knew the answer because I'm covering it with them. Like I'm covering it with you. I cover this. I got to know, what are we doing? And I went straight to the file room, and I knew what the application, that interview sheet, I knew what it said. I said, you know what you put down for spouse? She said, yeah. I said, no. I said, yeah, you lied. I said, had you told me you were married, I would have told you that we were at 4 years, 9 months, and I'm begging for 3 months. So I'm pretty much figuring we're not going to get Title II. But I know we got Title 16 because you're not married. And we're going to get some income, some money in terms of benefits, not income, but we're going to get something. And that's why she ended up at $16.73 a month. And she said, well, the rest of the story is she's like, well, we're separate and apart. And I said, Social Security doesn't care. You're married on paper. And whatever, I think he made 30 grand. And so they take into account what the income is. And when I say that, they're going to look to see, do you have savings, 401k, anything in checking? Is anybody providing you room and board? They're going to consider that income. I represented aunt and uncle, a little bit more well-known, but I'm not, that had a nephew in North Little Rock. They put him up in an apartment. They paid for his food, his clothing, the whole 9 yards. Okay. He didn't have Title II. He had Title 16. By the time we were done, we won the case. His benefit was a couple $100 a month because they took into consideration that the aunt and uncle were paying for his room and board, paying for his food, paying for his clothing. Now, to finish Patricia's story, just obviously at $16.73 a month, that doesn't end there. She can then go get a divorce if they've been separate and apart for that long, get a divorce. And then what Social Security will do is they'll go ahead and increase the benefits based on what they have on paper. So that's just something to keep in mind. I represented a lady over in Mayflower, and she was married, and her husband made $15,000 a month. $15,000 a year. Yeah, a month would be good, but made $15,000 for the year. And I told her, I said, okay, she didn't have Title II. We don't have 5 out of 10 years. I said, contact Social Security and find out what will you be getting if you win? Just so you understand what you're going after, what's at stake. She did, and it was about the same as Patricia's case. It was going to be about a couple $100 a month. Even though her husband didn't, $15,000 in Arkansas, not a lot of money, but that's what Social Security told her. So now you're going after a couple $100 a month. Any questions so far? Okay. The first case I handled, I'll finish one other part. $16.73 a month. Guess what? The attorney's fee is already, it's done by the government. I don't have to, in fact, now they have a direct deposit. The government wants to make sure, they got tired of sending out checks. I don't care if it was a Social Security retiree, a disability. They got tired of sending out checks, so they want a bank account. They want information. They don't want to hear the check got stolen by the neighbor. So now they want a bank account that they can deposit everything in. So now, even on a Social Security case, they will direct deposit the attorney's fee separate from the client. And then that way you don't have to try to chase your client down either in case there's an issue there. But the attorney's fee is 25% of back pay, and it caps at $6,000. And again, every time somebody comes in, they say, well, do you know how much I'm going to get? No. In fact, I don't know how much the attorney's fees are going to be. I don't know how far back we're going to go in terms of back pay. And I said, government does it all. My job, my goal, prove you're disabled, let them do the rest. Now, as I was going to say, the first case I ever handled was for a 26-year-old. And you know, there's a little political in this, obviously, as y'all see, with disability and how politics can work on both sides of this equation. In Social Security, what's supposed to happen is in 2 to 3 years, they're supposed to go back. If you've gotten somebody on disability, they're supposed to go back and see, have they gotten better, worse, or are they about the same? And obviously, if they've gotten better, it could be that the government will be sending them a note saying, now you owe us $12,000 because we considered that you were able to work about a year ago. But they're going to check on these. They're supposed to check on them. And so you want to kind of caution your people to make sure you want to keep your appointments. You want to keep the medical going, because when they come calling and it's been 3 years since you've seen a doctor, they're going to cut them off. They're going to say, well, obviously you're well now and you're able to work. The lowest I've gone is 21. Now, and it covers a point I wanted to make. In Social Security, you can go with what is called a closed period. As I said, you got a year to a year and a year to be off or reasonably anticipated to be off work. This lady was off work 18 months due to a bad car wreck. She injured everything from head to toe, facial fractures down to the toes. I'm not kidding. And at the time we were going to a hearing, she had already started applying for jobs. I mean, she wasn't going to be disabled for life at 21. And so we went to the hearing, and it was Judge Dan Stripling, who's not there anymore. And I said, Your Honor, we're going for a closed period, 18 months, and she's already applied for 3 jobs. So he said, oh, okay. So he starts asking her questions, goes about 10 minutes asking about all the bones she had broken. And he looked at me and he said, I don't understand why Social Security didn't just approve this case. We're done. We're done. Unemployment versus Social Security. This will come up from time to time, and it doesn't come up as often nowadays as it used to, but people will say, I'm drawing unemployment, or I'm looking to try to draw unemployment. Will that affect my Social Security case? Well, yes, if the judge finds out, because what are you saying in unemployment? Well, in unemployment, what you're saying is, I can work, I just can't find a job. And of course, you're attempting to find 3 jobs a week, from what I understand about unemployment. Social Security, you're saying, I can't work. Doesn't matter if I find a job, I'm not going to be able to do it. Well, obviously, that's in conflict. And if a judge is able to find out that you're obviously applying for unemployment, or you have applied for unemployment, they're going to be wanting to understand, why are we saying we can get unemployment, but you're saying you're disabled. Workers' comp versus Social Security. I do personal injury, workers' comp, and Social Security. And workers' comp, you will find if people get checks every 2 weeks, temporary total disability, what have you, permanent partial disability, they may be getting $800 from workers' comp. If they qualify for benefits under Social Security and the benefits are $800, it's a wash. Social Security doesn't send you any money. If it's $1,200 by Social Security, then they'll send you $400. So it's called an offset. So most of the time, in workers' comp cases, you wait till the case is over to then try to apply for Social Security. These are administrative hearings. And what that means is I've done cases in Texas, Arkansas, Tennessee. I'm trying to get to Hawaii. Still trying. Alcohol. You will find that alcohol comes up in a few cases. It will always end up being in a few cases if you do this on a volume business. Alcohol, when it first came out, they said, if you have an alcohol issue, we're not approving you for disability. We're not about to pay all the alcoholics a check. Then they switched it and said, okay, it's an addiction. They can't control it. So we'll allow it. And then they flipped back to, no, we're not going to allow it. So now we're back into if you've got alcohol issues, and what the judge is trying to find out is the alcohol the reason why you can't work, or is it the physical and mental conditions that you have? But if the judge gets an overriding, it's alcohol that keeps you from working, you're out. Most of these hearings, again, judges are different. There's one judge that I had last Friday, and he likes to start out. He'll say, Mr. Claimant, you and I are going to do the bulk of the work here, and Mr. Odum can chime in at the end if he has any questions. And then there are other judges that sit there and say, you may inquire, let's go. And so you again, knowing which judge you got and what they're looking for. I tell my clients that they need to be careful. In fact, I was talking to one this morning about talking too much. I know I always tell them, I want you to be as verbose as you can when you're describing the problems that keep you from working. But if you start going down that road on other issues, you could end up in a place where the judge will say, oh, really? Is that what you said? Oh, okay. Well, let's talk about that for a minute. As an example, trips. There's a judge over there the same judge that's sitting there asking about whether or not you can do a receptionist job, asked one question, and I saw him at a seminar one time talk about this. He said, he'll ask, in the last year, have you been out of the state? Out of the state. He's not asking, have you been on a trip? He just wants to know, have you been out of state? And he said, I've heard people tell me about, oh yeah, I went on a cruise, but it was just miserable. It was terrible. Went there for 10 days and I couldn't, my back hurt me. I didn't enjoy it. He's like, don't tell me that. Don't tell me that. So that's my point about you want to make sure that they don't get too verbose. You want them to explain as much as they can about what keeps them from working. And that's the beauty of these cases. Quite honestly, that's the beauty. There's nobody on the other side. There's not a defense attorney getting in their face going, this is, where'd you go last week? Were you in Florida? We got a private investigator watching you. You out mowing the yard? You said you can't drive. We got a picture of you driving. There's nobody doing that. The other side is the judge. And that's the one they get to talk to. And most of the time, that judge will allow them, as much as you want to tell me, I'm not going to cut you off. Anything you want to say. And I'll tell them, I'll sit there and say, and as a catch-all question, I'll say, okay, I know we've covered everything. I know we've covered your back, your neck, whatever. You're bipolar. Is there anything you want to share with this judge while you have his ear or her ear? Eyeball to eyeball, kneecap to kneecap. Anything else, let her rip. And I mean, it's one-on-one. And there's no one else to sit there and criticize them for what they're going to say. These cases can go, if you lose before the administrative law judge, you have the ability to appeal to the appeals council. I think it's in West Virginia. I've done many of those. And they do look at it and they do review them. I've won on appeal. If you don't, you can then go from the appeals council to federal district court. Now, I will promise you that if you've lost before an administrative law judge and you've lost at the appeals council, what I normally tell my people is to go reapply. Just go reapply. We're not gonna, it's not worth trying to keep the process going, to go to the federal district court and have a magistrate hear it. And then if you lose there, go to the 8th Circuit Court of Appeals, which ironically I did once. I actually took a Social Security case to the 8th Circuit. It was on a Thursday that I had the hearing. I drove up on the Wednesday, took in a Cardinals game and went in there, and it was and I know I had not done any appeals in a long time, but I remember back in law school, you have to go in there and say, okay, I want 9 minutes at the beginning and 6 for rebuttal, whatever. I didn't remember that. I went up to the room and the clerk was in there because the hearing that was at 9, one of the lawyers went to the hospital. And so the guy that was there said, hey, Kevin, you're probably going to have to go first. I don't think we're not doing the 9. And the clerk looks at me and he says, what's your name? And I said, Kevin Odum. And he said, did you go down to the clerk's office to check in? I said, no. It's like, let me take you. So we went down and I did the whatever 9 and 6 minutes. And I had a 3-person panel. And I had 2 judges on the outside that were doing just beautifully with me. I thought they were they were just questioning me, going with me. And hey, this is what I want. One judge in the middle said, you basically lost below and want us to reverse it for why? I'm like, okay, that's a no vote. Now let's keep talking to the 2 on the outside. 3-0 no. It was, they were very nice. They smiled and then they said, no. Date of onset. The mainly it's going to be the last day worked. Now, as I explained in Title 16, you're going to go to the date of the application. That's by law. They start then, but the last day work can be interesting if you filed an application in 2021 and your last day work might have been in 2020, or it might have been in 2019. So, if you put on, most of the time, judges will go back a year. They kind of, start going, okay. I remember I had one client that wanted to go back. He said, well, I want to file in 2013, and he wanted to go back to 2007. I said, no judge in his right mind is going to do that. Could you imagine at $1,500 a month going back 7 years? I said, the government's not writing that big of a check. That's not going to happen. Which brings up another interesting point. Sometimes judges, you can kind of gauge them on what they're willing to do. And I say that to say this, the magic age in Social Security is 50. 50 and older 50 is a good number. Law gets a little lighter at 50. Law gets even lighter at 55 in terms of what you have to prove in a disability case. So sometimes you may have a client that the judge will look and see what's the date of birth. And if you have a 57-year-old, they may say, okay, I'm not going back to when they were before 50, when they were 54 or 53, but if you'll amend the onset date to their 55th birthday, I'll approve the case. And so you can kind of see what a judge, and sometimes they'll tell you, they'll come out and straight and say, I've got a problem with when you want to start the benefits. They're not going to say it that way. They're going to say, I have a problem with your onset date. We got to do something about that, which was basically him or her saying, I'm not approving the case with the way you got it right now. So you better change it. And I'm always amused when they say, okay, if you'll amend this date to this date, I think I'm okay. And then they say, but you got to talk to your client and see if they're okay. This is during the hearing. And so you have to take a brief recess. You go out in the hall, and it's the quickest conversation you can have when you say, if you want to win, we got to amend the onset date. If you don't, we're going to lose. What do you want to know? And it's like, let's amend the onset date. Okay. So, trying to see any questions before I. I got one more thing I wanted to cover, if it's okay. Is it okay? I already told you all about how people will receive shut-off notices. There'll be eviction notices. In Social Security, you can ask for what is called a critical dire. I don't know if and that's to try to see if you can get the case moved up. It's not guaranteed. It's not just because I'm a lawyer and I send in a request for critical dire that they're going to give it to you. There's two things they're looking at. One, they want to see some notices, shut off notice, eviction notice. That's one. Two, they're going to want to know, do you have anybody in Arkansas that you can stay with? Do you have any family in Arkansas? So even though I send it in and I say, hey, please move this case up, they don't just say, oh yeah, we'll move them up. I already told you they were 8,000 cases behind, 7,000, 5,000. Yeah, everybody's got a critical dire. So they don't just move them up, but they will at least look into it to see if it is enough to where they should move it up. Yes, ma'am.
Testing. No. Yeah. Okay, these are from our virtual attendees. Can you speak about how administrative law judges will look at a case where the disability is a chronic liver disease that may be caused from alcoholism?
It would probably still come into how does it affect their day-to-day living? And I think what they're looking for when it comes to alcohol is the people that are still drinking and drinking daily or routinely. And where they pick it up is going to be in the medical records. In that particular case, if we've already got a chronic liver disease, I'm going to bet we don't have alcohol being an issue anymore in terms of drinking, or then the judge is going to question their sanity. But if it's mainly when you see in the records where they say, I actually had this recently, the guy had put in the medical records that he drinks bourbon a couple of times a day, or goes honky tonking. Literally, that was the words. I thought we were past those days, but no, I think it's more, are you actively drinking? I think if you get to the point where you have that's a different story. You can argue that.
Okay, and then we have, will a 401k be relevant to a Title II determination?
No. Why? And the why of that is Title II is not based on income. Title II is you did your job. You worked and you paid into the system. And so income does not come into play with Title II.
Are you familiar with Judge Christo's unemployment ruling from August 9th, 2010, specifically dealing with unemployment insurance benefits and how they should not be held against a claimant and his disability?
I am not, but I just know. And that's, again, it's not brought up as much as it used to be. It's not, it's just something in case your client brings it up, or in case it gets asked. You try not to. I mean, I don't tell my client, hey, go in there and explain that you filed for unemployment or anything else.
One more. What if someone becomes disabled, but they have already started receiving Social Security retirement benefits? Can they still apply and have a monthly amount adjusted? That's
a great question. Because that'll come up with people that are older. You can get disability benefits and have retirement. And again, it's going to be what's the numbers? If you were disabled before you got the retirement benefits, and let me just make a number up so it can be obvious. Before, and we've moved it from 65, 62, 68, just depends on when you're retiring. But under disability, if you could get $1,600 a month under disability, but under retirement, you're going to get $1,200, then yes, you'll get the difference of $400 a month.
We had some more come in. What about childhood onset? If your client clearly has childhood onset, how long after 18 do you wait to file?
Well, I'll answer that in a way. Most of the time, children, you can get disability for children. And the yardstick for a child is the deficit so detrimental that and the way I put it is, it's not the normal child. We all, 13-year-olds can be 13-year-olds, and we know that. But you want the one that is so abnormal that, as an example, you got to be there when they get on the school bus. You got to be there when they get off the school bus. They punch holes in walls. Mainly what they're looking at is how do they do in school? Are they being suspended? Are they in the principal's office daily? How are their grades? If they're able to move up every year, then a judge is going, well, they're moving up every year. But if they're having to be held back and they're in the principal's office, then that's the yardstick that they're looking at. Now, once you turn to be an adult, at 18 is when you apply, and that's when you're on the adult standard. And the adult standard is, can you do any job in the United States? So now we moved it from child to where we're no longer trying to figure out, is this the abnormal child, so to speak? We're now proving, can the person do any work? Hold on a minute. I got two. Go. Yes, ma'am. Okay.
Going back to retirement, if someone was a police officer, fireman, teacher, they can retire earlier than most of us. So if they retire, then have a serious car accident, major stroke, that kind of thing, can they get SSDI even
Yes.
though they're on retirement?
If they paid in 5 out of the last 10 years, yes, ma'am, they can make that claim. Yes, Anne Marie.
When you're saying that they need to do any type of work, with people being able to work now from home, have successful business, is that becoming more difficult to prove I cannot do any type of substantial vocational work? Because you can run a business from your office chair now without leaving. So is that determining cases any differently now?
The one I would give an analogy to is, I remember I was representing a lady that was able to go to school from home, and she went to the University of Phoenix. However, that was you didn't have to do it every day. You could do it remotely and stuff, and it wasn't a 40-hour grind. If that person working from home can do 40 hours, yeah, I mean, that's going to be a problem. And to go to another step of your to answer, they look to see, do you have what is called substantial gainful employment in terms of what money are you making? If you've made a certain amount of money in Social Security terms, then you will not qualify because you made too much money. So depending on what that job is, how much it's going to be depending on how much income they're making in a year. If they made $30,000 working from home, they're not going to get disability. Yes, ma'am.
Thank you, Mr. Odum. My grandson is on the autism spectrum. So if he was diagnosed with autism before school, and he will still be diagnosed with autism for his entire life, will he be eligible for disability when he becomes an adult?
Again, that's gonna depend on, is he able to work? Obviously, people that are autistic can get into the workforce. So it's going to depend on how much the autism affects his ability to work. Okay, go ahead.
So maybe he can work, but maybe he can't get a job. Is that part of the equation?
Yes, ma'am.
I can work, but I have to apply for another job every other month.
Yes, that goes into the equation, and that gets into where you'll find those kind of situations. It'll be a family member that ends up employing them, because that's going to be the only one that'll put up with whatever they need to do. If they need to be off, if they're going to miss time, it'll be a family member that'll say, I'm okay with that, versus the competitive workforce environment. Yes, Judge.
Just as a follow-up to that, I guess in a Title 16 claim, you indicate that Social Security, for example, if you have a family that supports an adult child who otherwise could not find employment, they actually would get, like you get an apartment for them or you pay food for them, they actually would get penalized for that so you just let them fall off the plate, you just let them
That's
fall.
Social Security. That's Social Security. I can't tell you how many times I've been asked that question in terms of, so what am I supposed to do? Am I supposed to lose the house? Am I supposed to lose my family? Am I supposed to lose all that just so I can qualify for disability? And I say, that's what the government says. Because they're not changing the rules. And when it takes 18 months to 2 years to find out what the answer to that, if you're gonna win. Yeah. So if I'm the government, I'm saying, hey, go back to work. So then if you go back to work, you just proved you weren't disabled. Yes, ma'am.
On your chart up there, what is to the right? AEWE, low.
Age, education. Go ahead. I'll wait. Age, education, work experience, last day worked, and medical. And let me cover one more point on the work experience, because I actually have this coming up tomorrow, and it's what they try to do is find out, do you have other skills? And as an example, I've got a lady tomorrow that was a manager. Okay, well, she had the ability to hire and fire. So that gives her more skills than normal. And they look at that. They look to see, okay, well, that's something else that we can add. She was able to do that. Now that's different. And if you represent anybody that's in fast food, McDonald's, those Wendy's, they'll hire somebody for $30,000 a year and make them work 72 hours, and then they'll call them 72 hours a week, and then they'll call them a manager. Well, they're not a manager. They're just a workaholic that they're working them, and they don't have the ability to hire and fire. But by having that word manager, they'll sit there and say, okay, does that help? So I'll go one more. I represented a gentleman one time that was 57 years old. He had come from California to Hot Springs, living with his mom, and except he qualified for Title II. And I told you about the judge that said medical, medical, medical. I had 16 pages of medical, and that was it. 1/6. I'm not kidding. 10 of it was from Social Security. Social Security had sent him out to have an evaluation done. And they sent out the typical form that the doctor fills out, and that was it. And then we had 6 other pages. He was 57. I told him, I said, and he didn't have any insurance. He didn't have any way, but he had laid tile for 32 years. And I had set his expectations pretty low. And that's another thing, as lawyers, we deal with foreseeability and odds. And one of the things, disappointments based on expectations. And if this is a medical driven type situation, if you've got 16 pages, that's not good. We went to the hearing. It was Judge Gorey, who's a Little Rock judge. And he asked the guy, he said, okay, 57, yeah. Did tile, yeah. How many years? 32. Knees and back were what bothered, but we didn't have any medical to document it. We got his word. So he had to ask the vocational person, are there any transferable skills? Which goes back to that manager, the manager. And the vocational person said, no. And Judge Gorey had glasses on, and he takes glasses off and he sets them down. And he says, well, then I have to tell you that under the law, you are disabled because you have no transferable skills at 57, and that's the law. And the guy that I had pretty much beat up enough to explain, you're probably not going to win because we don't have any medical, was like, I thought you said that we had a difficult case. And I said, we did, because some judges would take 16 pages of medical and say, we don't have anything to document your problems. I said, but we caught the right judge today. Thank you. Go ahead.
Practical question. If you have 3 banker's box of medical, do you send them or do you try to go through and edit? I assume.
They, in Arkansas, you have an electronic file. You can, I still do it by faxing, but you can actually probably scan them in and upload them to the system. In Memphis, Tennessee, they still got the same paper files, which is just bizarre to me. I mean, you literally, they'll have one of those old time files, and you got to sit there and flip through to see what medical they have. I didn't know we were that ahead of times, but what they're going to want, and they'll do it. Most of the time, Social Security will get the medical records, or when you go to look and find out, when you log in, you can see. Okay, the record stopped as of January 2019. Well, a judge is going to want records that bring it up to speed. So what you're trying to do is whatever records you're talking about, you want the records from 2019 up to speed so that they can see what's been going on. So if it's all those records, yeah, you want to send them in. So I'm good. I'm good.
How or when would you apply for an individual with severe intellectual disability that is going to affect employability?
And anytime. There's no the thing of, as you got to understand, I think it's such a political process right now that they're going to turn you down. There's 175, I believe it's 175 categories that they're going to approve you on paper. If you're a stage 4 cancer, you're not waiting. You're not going to be waiting. They should approve you on paper. But you know, it's whenever you want to apply, because at a certain point, the question comes up about, well, why didn't you apply earlier if you thought you were disabled?
I think there's a typo on this, but I'm going to read it and see if we can decipher it. Can you touch on how to handle case when client does due to disability before hearing, and what family qualifies for benefits they would have gotten?
Can you say that
Not really,
again?
not really sure what's being asked. Can you touch on how to handle case when client does due to disability before hearing, and what family qualifies for benefits they would have gotten? Oh, it's supposed to be dies. What to do when a client dies.
It usually will be, again, it'll go back to the last day worked, or if it's a Title 16, it'll go to the date of application. And that's a good, just a segue from that. Obviously, if you qualify for Title II, their kids will be part of that equation as well, in terms of benefits that they will get as a result of being a child of the disabled person.
I think that's it on the questions, or just some more comments.
Okay. Thank you. Thank you. Thank you. Was that